Dear students, viewers, and the subscribers, welcome to the IAS Mentor. This will be our episode number 5 in the series Indian Polity Current Affairs for Prelims 2025. If you see in our previous lectures, we have seen an introduction video, then we have covered the topic of executives. We have covered the most relevant and the most important topics where the probability is higher. In the topic of executives, then in episode number 3 as well as in episode 4 we have covered the topic of legislature. There also we have seen number of important topics especially topics like the pro tem speaker, the powers and functions of the speaker, because all these things were related to the current affairs. And presently in this episode we are going to discuss about the judiciary, and here in judiciary also we have some important topics, especially the appointment of ad hoc judges to the high courts. Recently the Supreme Court has given a judgment on this. They have relaxed certain norms with regard to appointment of ad hoc judges. We have a new Chief Justice of India, 51st Chief Justice of India. So how the Chief Justice of India is appointed, that could be a potential question. So in this lecture also we have a number of important topics. So the idea is, as I already said, that this series will try to give you 50 most important topics which is relevant for the Prelims 2025 from the subject of Indian polity. So the idea is, if the students have done the conventional part, on top of the conventional part, if they do the current affairs also, so to help them to get maximum scores from the subject polity, which based on my experience I can say not less than 80% of the marks can be scored, provided yes you have done your conventional areas also very well. You have covered the previous year questions, you have done the basics. On top of that, if you do the current affairs, that will help you. So this is just not a current affairs series, it will also involve certain element of revision of the conventional areas as well. Of course, there's a limit for that because more and more focus is on the current dimension, certain facts relevant to all those things. The most important element of this particular series, I would say, not only about that we are touching upon the important current events, but also students will get to know what areas probably the UPSC may ask the question. So probably that will also give them an idea as to how they have to prepare in the future. So that's the reason I said that while it is very relevant for the students preparing for 2025, but the students who wanted to prepare in the future also, they should also watch that series, so that in the future whenever you read a particular current affairs topic, you get to know which are the areas very important, which are the areas which may not be very important. So therefore I'll emphasize, I'll make notes on those areas. So all those things will be made clear as we'll proceed in this particular series. All right. So with that brief introduction, let us get into the topic of judiciary. We have 5 topics to cover. As I already said, the series will cover 1 year of current affairs, most important areas, right from May 2024 till April 2025. So let us see some of the important topics from judiciary. So the first topic that I am going to discuss is the 51st Chief Justice of India has been appointed. After the commencement of the Constitution, when the Supreme Court started functioning, till this point of time, 51st or 51 Chief Justices have assumed charge. And the latest one to be appointed as a Chief Justice of India is Justice Khanna. And Justice Khanna is coming from a legal background. And not only is coming from a legal background, of course, a judge should have a legal background. But what I meant to say is Justice Khanna is coming from a family where there have been more judges. In fact, Justice Khanna's uncle was Hansraj Khanna, H.R. Khanna, who was also part of the famous judgment which was given by the Supreme Court, what is called as the ADM Jabalpur case. I will also briefly touch upon it as a part of the facts. But now let us try to understand the current context and what are the possible areas a question can come from this particular topic. It's because of the fact students preparing for UPSC, they should know that what is the basis or what is the procedure to appoint the Chief Justice of India. While if you look into the Constitution makes it very clear that the President shall appoint the judges of the Supreme Court as per what is given under Article 124 of the Constitution. It is Article 124 which talks about all those things. So if you carefully read Article 124 of the Constitution, it says that the President shall appoint the judges of the Supreme Court in consultation with the Chief Justice of India and such other judges of the Supreme Court and High Court as he may deem necessary. This is the only thing that is given under Article 124. But over a period of time, based on the interpretation of the judiciary, now what is happening is the judges are appointed based on what is called as collegium system. So this is what the Supreme Court has interpreted. So presently the judges of the Supreme Court are appointed based on collegium. So the thing that you have to keep in your mind is there is no specific procedure that is mentioned in the Constitution as to how the Chief Justice of India is to be appointed. So what is the thing that is followed presently to appoint the Chief Justice of India? The Chief Justice of India is appointed based on a conventional practice that has been set in. So the first thing that you should remember is there any specific procedure that is provided in the Constitution? No, with regard to appointment of Chief Justice of India, he is appointed based on a conventional practice. It's a very strong convention. But when I say convention, conventions are convention. It does not have any constitutional backing. That means, can these be violated? Yes, it can be violated. But what is this particular convention? Let us try to understand. The conventional practice that is followed right now is the outgoing Chief Justice of India would recommend the name of the senior most judge of the Supreme Court to be appointed as a Chief Justice of India to the President, and then the President will appoint the senior most judge in the Supreme Court as recommended by the outgoing Chief Justice of India as the Chief Justice. So this is the convention that you are following in our country. So therefore make it very clear in your mind, this is not prescribed in the Constitution. And according to the convention, the outgoing Chief Justice, the 50th Chief Justice of India, Justice D.Y. Chandrachud, he recommended the name of Justice Khanna, who was now appointed as the Chief Justice of India by the President of India. So this is the convention that is followed. You will have to keep it in your mind, very, very important. But when it comes to Justice Khanna, who is appointed as the Chief Justice of India presently, let us try to know certain facts, because UPSC sometimes can ask questions from the facts as well. So therefore we should be aware of the facts as well. In fact, he is among the very few judges who was appointed directly from the High Court, even without becoming the Chief Justice of a particular High Court. So Justice Khanna was never a Chief Justice of a particular High Court. In fact, he was a judge of the Delhi High Court, and directly from the parent High Court, he was elevated as the judge of the Supreme Court. So this is something probably you may keep it in your mind. I am not saying that it is a very important thing, but in case, because this normally does not happen to most of the judges, so it appears to be an exception in case of Justice Khanna here. Apart from that, you should also understand that Justice Khanna is nothing but he is related to Justice H.R. Khanna. The present Chief Justice is related to, in fact, Justice H.R. Khanna is the uncle of the present Chief Justice of India. And what is the speciality of Justice H.R. Khanna? He was seen as a beacon of what is called as the right to liberty of the individuals. In fact, there was an infamous case which is called as the ADM Jabalpur case, which happened during the emergency time in 1976. And a matter was brought in front of a constitutional bench of the Supreme Court that whether the right to life and liberty under Article 21 of the Constitution, can it be suspended during national emergency? Can it be suspended or not when there is a national emergency? In fact, all the 4 judges apart from H.R. Khanna were of the opinion, yes, during national emergency, the enforcement of fundamental rights can be suspended. So therefore, which includes the right to life and liberty as well. But in fact, it was only Justice H.R. Khanna who said that no, the right to life and liberty cannot be suspended even during the fundamental rights. And it was a only dissenting opinion which later became part of the Constitution. In fact, his judgment led to the 44th Constitutional Amendment Act in 1978. And by the virtue of 44th Constitutional Amendment Act 1978, now we know that while most of the fundamental rights enforcement can be suspended under Article 359 except Article 20 and Article 21. So therefore, it was his dissenting opinion which later became part of the Constitution, and to that extent Justice Khanna, H.R. Khanna was known to protect the fundamental rights, but because of this particular judgment, Justice H.R. Khanna has to pay a huge price, because it is said that because of this particular judgment, which then Prime Minister of India did not like, and subsequently the convention that is to be followed was not followed. In fact, Justice H.R. Khanna was the senior most judge of the Supreme Court at that point of time, who is supposed to become the Chief Justice of India next. But after this judgment, he was bypassed by junior judge, and then the junior judge was appointed as the Chief Justice of India. and subsequently Justice H.R. Khanna resigned as the judge of Supreme Court. So these are all some historical facts probably you can remember. UPSC may not go to that extent, but in case if they ask, you should have an edge in answering all these things. And apart from that, as a Chief Justice of India, whoever is the Chief Justice of India, he is also the master of roster. When I say master of the roster, he is the one who will allocate various cases to different benches in the Supreme Court. So this is one of the power that he exercises. So this is something that you can keep in your mind. So all these things are very, very important. So what are the areas that you should remember from this particular topic? The first thing is that how the Chief Justice of India is appointed, it is only a conventional practice. And when it comes to Justice Khanna, presently who is the Chief Justice of India, he is the 51st Chief Justice of India. And he has never been a Chief Justice of any of the High Court. And then he is related to Justice H.R. Khanna, and he is also the master of roster presently. So try to remember these facts as well. So please come to the next topic, very, very important topic. The Supreme Court has recently stayed the order of Lokpal, where the Lokpal said that they can exercise power over the judges of the High Court. And in fact, in which context this news came, the Supreme Court has taken a suo motu cognizance of this particular order which is passed by the Lokpal. So what is suo motu cognizance? Suo motu cognizance means on its own, that nobody has filed any petition in front of the Supreme Court. But the Supreme Court itself has taken cognizance of this and made it as a case, and they have stayed the order that is passed by the Lokpal. Now you should ask a question, this is of lot of current significance, you should ask a question. First of all, why would Supreme Court take a suo motu cognizance? What is so important in this? And what is the order that is passed by Lokpal against the judges of the High Court? What is Lokpal as an institution? So a number of things are connected here. So let us try to break all these things one by one. In fact, we know that Lokpal is a statutory body established by the Lokpal Act, and in fact the Lokpal Act was passed in 2013 and subsequently the Lokpal came into existence. And today if you ask me what is Lokpal, the Lokpal is the highest anti-corruption body in our country, or it is the highest ombudsman in our country to deal with the charges of corruption against the public servants. So the word public servant is very, very important. Although there are certain categories of people who are exempted from the purview of the Lokpal, but Lokpal in general can take up cases against the public servants. Now the recent order that is passed by the Lokpal is of the opinion, it's because the Lokpal is of the opinion that the judges of the High Court fall within the ambit of what is called as public servants. And because the judges of the High Court fall within the ambit of the public servants, and if any allegations or charges of corruption against a judge of a High Court, then such a matter can be investigated and inquired by what is called as a Lokpal. So this is the latest order that is passed by the Lokpal, which the Supreme Court has taken suo motu cognizance of this, and the Supreme Court said this order and the interpretation that is given by the Lokpal is very disturbing, because this interpretation, if it is allowed, it will have an impact on what is called as the independence of the judiciary. And because it will have an independence of the judiciary, we are putting a stay on this particular order. Although final judgment has not been passed by the Supreme Court, but the Supreme Court has passed this particular stayed this particular order. So this is the overall current scenario that has happened. Now let us try to break it down as to how the Lokpal was able to declare in their order that the judges of the Supreme Court will be part of what is called as public servants. Because in general the law says whoever is a public servant, they are under the purview of what is called as Lokpal when it comes to corruption charges. And what was the reason that was given by the Lokpal to say that the judges of the High Court will fall under what is called as public servant within the definition of the law, that is the Lokpal Act. But the Lokpal itself clearly said that the judges of the Supreme Court will not fall within the purview of what is called as public servants. So who will fall within the purview of public servants? The judges of the High Court. And what is the reason that they have given for all those things? The reason that was given is, the Lokpal said, look into section 14 of the Lokpal Act. Because it is section 14 of the Lokpal Act which defines as to who is a public servant under the Lokpal Act. So if you look into section 14 of the Lokpal Act, the section 14 of the Lokpal Act makes it very clear as to who can be considered to be a public servant and who is considered to be a public servant. So please read section 14. It says that any person who is or has been a chairperson or a member, officer or employee in any body or board or corporation or authority or company or a society or a trust or an autonomous body by whatever name called. It may be a body, trust, whatever be the name be it called, established by an act of parliament. That's the keyword. So any person belonging to any board, any trust, any other organization, whatever be the name, it may be called. But if that person is working as a part of any of these organizations, but established by an act of parliament, then they will fall within the definition of what is called as public servant. So the Lokpal is saying that this is the definition of public servant. Now come to the position of the high courts under the constitution. If you look into the constitution, the high courts are not directly established by the constitution, because the Lokpal said, if you look into the constitutional provision, and what is the exact constitutional provision? Article 214 of the constitution. Article 214 of the constitution says that every state shall have a high court. There shall be a high court for every state. But it doesn't mean that the constitution itself is establishing, but the high courts in our country existed even before the commencement of the constitution. Therefore, the therefore the Lokpal said that this article 214 of the constitution is intrinsically recognizing all the existing high courts. Because if you see the history of high courts in our country, the high courts were established based on the High Courts Act 1861. And then some of the other high courts were established based on the Government of India Act 1935. And then subsequent to the commencement of the constitution, a number of high courts in our country are all established by an act of parliament. The high courts are not directly established by the constitution, unlike the Supreme Court of India. So the opinion of the Lokpal is that Article 214 of the constitution intrinsically recognizes all the existing high courts. And apart from that, Article 214 of the constitution, giving along with the other articles, allows a parliament to make a law to establish various other high courts in our country. Say for example, the High Court of Delhi, the High Court of some of the northeastern states, and many of the other high courts today, including the High Court of Andhra Pradesh and number of the other high courts today, they are all established by an act of parliament. So therefore, the Lokpal is of the opinion, now all these bodies or all these high courts are considered to be established by an act of parliament, and hence the judges who are part of these bodies would fall within the definition of what is called as section 14 of the Lokpal Act. And in fact, they said very clearly, any person which is mentioned in the law, that is in the Lokpal Act, any person does not give any exemption to a judge of a high court. And the high court judges or the high courts are established by an act of parliament, and hence judges occupying positions in the high court, they will fall within section 14 of the Lokpal Act, and hence therefore they would be considered to be public servant, unless and until they are specifically exempted, and there is no such specific exemption under the Lokpal Act, and hence they will fall within the definition of public servant. And hence if there is any charges of corruption against the judges of the High Court, they will be within the purview of what is called as the Lokpal, which the Supreme Court found it is very disturbing. And the Supreme Court said that if we are to allow this particular order which is passed by the Lokpal, then it will have an impact upon the independence of the judiciary. So therefore, they have taken a suo motu cognizance of this particular order, and they have stayed this particular order. But is there any previous judgment of the Supreme Court where the judges of the High Court and the judges of the Supreme Court were considered to be public servants? So therefore, what is very important for you is you should remember what is the definition of section 14 under the Lokpal Act. That's one area probably you should remember. But otherwise, this judgment per se is not very important because it has been stayed. The Lokpal order is stayed out by the Supreme Court of India, and whatever is the final thing will be what is passed by the Supreme Court of India. But at least you try to remember what is section 14 of the Lokpal Act, who may be considered to be what is called as a public servant. And what is a view that is taken by the Supreme Court of India? In fact, even before this Lokpal order, the Supreme Court of India has made it very clear way back in 1991 itself, in a case which is called as the Veeraswamy versus Union of India case 1991, where both the judges of the Supreme Court and the High Court would be considered to be public servants within the purview of the Prevention of Corruption Act. So not under the Lokpal Act. So under the Lokpal Act, whoever is considered to be public servants, only over them the Lokpal can exercise jurisdiction. But under the Prevention of Corruption Act, the Supreme Court has already recognized both the judges of the Supreme Court as well as the judges of the High Court to be part of what is called as a public servants, and hence even the judges can be prosecuted as per the Prevention of Corruption Act. But however, in order to prevent any false cases against the judges, condition was put. A caveat was introduced by the Supreme Court of India in this particular case. Whenever any prosecution or investigation is to be started against a judge of a Supreme Court or a High Court on the grounds of corruption under the Prevention of Corruption Act, then they have to take the prior permission from the President of India, and the President of India would act on the advice of the Chief Justice of India. So that is why I have mentioned that the safeguard here is that they have to take the prior sanction of the Chief Justice, but it is the President. But the President act on the advice of the Chief Justice. So finally, whatever the Chief Justice of India says, that is binding upon the President. So this is something that you'll have to keep in your mind. So what are the things that probably you'll have to keep in your mind? You'll have to understand as to what is the definition of public servant under the Prevention of Corruption Act. What is the definition of public servant probably under what is called as the Lokpal Act. So under the Prevention of Corruption Act, the law is very clear that the judges of the Supreme Court and High Court are already considered to be what is called as public servant, but not under the Lokpal Act, which is yet to be passed. So try to remember all those things, very, very important for your examination as well. Alright, so come to the third topic. Again, a very important topic, and this is an evergreen topic from the judiciary. So apart from all those things, I am not going much into the conventional areas. In the conventional areas, students try to look into the jurisdiction of the Supreme Court and the jurisdiction of the High Court. So these two areas are very, very important for your examination. But yes, right now our focus is on the current affairs. So one important current development that has happened in the last 1 year is the Rajya Sabha members called for the removal of, when I say Rajya Sabha members, the MPs in Rajya Sabha. The MPs of Rajya Sabha called for the removal of the Allahabad High Court Judge Justice Yadav. So what was done by Justice Yadav? And that has led to some of the members in the Rajya Sabha, I think to be very specific, 55 MPs in the Rajya Sabha, they have presented a notice to the chairman of Rajya Sabha to accept a motion for the removal of the judge of Allahabad High Court, Justice Yadav. In this case, so what has been done by this particular judge? The allegation against the judge is the judge has made some statements during a particular meeting which was communally toned. Or it can be also seen as, the allegation is, it can also be seen as what is called as a hate speech against the minorities. Where as per the newspaper reports, it is said that the judge has made a statement that the country, that is India, should be governed as per the will of the majorities. So therefore, it was a serious allegation against the judge. And hence the members of the Rajya Sabha, 55 members in the Rajya Sabha, they have submitted a notice to the chairman Rajya Sabha to introduce this particular removal motion against the judge. Now in this context, what the constitution says with regard to the removal of the judges of the Supreme Court and High Court also becomes very important for your examination. And this is not the only incidents. Recently after this, there was also incidents where a lot of cash was found in one of the judges in case of Delhi High Court. Later he was transferred to the Allahabad High Court, that is Uttar Pradesh High Court. So again, there may be a motion that may be taken up, although it has not happened till this point of time because the internal inquiry is still happening. So these are all instances where you should also be aware, because the removal of judges is closely related to all those things. You should be aware of what is the procedure with regard to the removal of the judges of the High Court and the Supreme Court, and what does the constitution says with regard to them. In fact, how the judge of the Supreme Court shall be removed is mentioned in Article 124, and how the judges of the High Court shall be removed is mentioned in Article 217. But if you see in the constitution, the judges of the Supreme Court and the High Court are to be removed by the same process, the same procedure. So what the constitution says? The constitution says that the judges of the Supreme Court and the High Courts can be removed by the President of India. So if a question comes, who is the removal authority? It is the President, but the President can do so only on the basis of a motion that is passed in both the houses of the Parliament by what is called a special majority. And for this motion to be passed by special majority in both the houses of the Parliament, first the motion has to be introduced, and then it should be subject to debate, and it has to be passed with special majority. So there has to be some grounds on which this motion can be introduced. or there should be some charge against which this motion has to be introduced. So what is the charges as per the constitution? It can be either proved misbehavior or what is incapacity. And the most important thing that you have to remember is what is proved misbehavior and what is incapacity is nowhere defined. It is not defined in the constitution. It is not defined. So that is the reason we'll try to understand how it can be convinced or how the houses can come to a conclusion that yes, the judge has involved in what is called as proved misbehavior or incapacity. We'll try to understand all those things. So what is the process? First, a motion has to be introduced, and that motion is on the grounds of proved misbehavior or incapacity. It can be introduced in either houses of the parliament, and if it is introduced in the Lok Sabha, it has to be supported by minimum of 50 members in the Lok Sabha, although it is not mentioned in the constitution. It is based on the Judges Enquiry Act. I will come to that particular area. So the motion has to be introduced either in the Lok Sabha or in the Rajya Sabha. So if it is introduced in the Lok Sabha, passed by a special majority in the Lok Sabha, then goes to Rajya Sabha, passed by special majority in the Rajya Sabha. This special majority has to satisfy two conditions. That is, it shall be supported by not less than 2/3 of the members present and voting, and that shall also satisfy the condition of absolute majority. Now, once it satisfies both the conditions, after it satisfies both the conditions, then it is passed to the next house. The next house also passed with special majority, and both the things have to happen in the same session. Then this motion is submitted to the approval of the president, and when the president gives approval, the judges stands removed. So this is the broader process that is given in the constitution. But the constitution did not talk about the minute details as to how the inquiry is to happen against a judge. And for that particular purpose, the constitution says the parliament shall have the power to make a law, and that law shall provide for the minute procedure as to how the entire exercise shall happen in the parliament. Accordingly, the parliament has enacted what is called as the Judges Enquiry Act 1968. So the Judges Enquiry Act provide for the detailed procedure as to how it shall happen. So as per the Judges Enquiry Act, it further elaborates certain conditions to be followed. So if at all it is to be introduced in the Lok Sabha, it has to be supported by minimum 50 members in the Rajya Sabha. If it is to be introduced in the Lok Sabha, at the introduction stage itself, it has to be supported by minimum 100 MPs in the Lok Sabha, 50 MPs in the Rajya Sabha. And it can be introduced in either houses. In whichever house the motion is admitted, then the presiding officer of that particular house has to appoint an enquiry committee, and that enquiry committee shall consist of 3 members. Now, why this enquiry committee becomes very important? This enquiry committee is important because it is this enquiry committee which is going to probe the charges against the judge. So whether there is a misbehavior or incapacity, only they are going to see this. And this enquiry committee will have 3 judges: a judge of a Supreme Court, a judge of any of the High Court, and a distinguished jurist. A distinguished jurist may not be a judge, someone who has a legal knowledge, someone who is a professor or a good, well-reputed academician in the area of law. So only these 3 people should be part of that particular committee. That committee will probe the allegation against a judge, either on the grounds of misbehavior or incapacity. And if the report of the committee is affirmative, then the House will take up the motion for further discussion. And when they pass it with special majority, then the motion is put forward to the next House. The next House also passed with special majority, then it goes to the president. The moment the president signs it, then the judges will be removed, and all these things has to happen in the same session. So this is basically what is given in the Judges Enquiry Act. So it is very important that the committee finds the judge guilty, and then only the House will take it up further. So if the enquiry committee itself does not find the judge to be guilty, so normally the motion is not taken up further. Now the most important thing is the process is so complex is because they wanted to ensure the judicial independence, and that's why a very difficult process and a difficult thing is given in the constitution as well. In fact, I said that what amounts to misbehavior or incapacity is nowhere defined in the constitution, but the Supreme Court of India, based on certain precedent, has said that what shall be considered to be misbehavior or incapacity. So the Supreme Court said these are all the examples of what constitutes misbehavior. If there is a willful misconduct in the office by the judge, if the judge is engaged in corruption, or if there is a lack of integrity on the part of the judge, or any other offense involving moral turpitude. Moral turpitude means something unethical. So these are all considered to be what is called as moral turpitude. would constitute what is called as misbehavior. So incapacity means which prevents a judge from performing his duty because of his mental illness or physical illness. So these are all the grounds for the removal of a judge of a Supreme Court or the High Courts. And if you look into the fact with regard to the judges and their removal, so far the impeachment motion or the removal motion against the judges has been triggered 6 times. I am not saying that it has been introduced in the House 6 times. At least there were talks or whatever bit it has happened 6 times in the entire history of India, out of which 3 times it has been introduced in the parliament, 3 times it has not been introduced. It was introduced against Justice V. Ramaswamy, but the key point that you have to notice, none of these judges has been removed through the impeachment process or the removal process. Not even a single judge in the history of India has been removed till this point of time. So it was introduced against Justice V. Ramaswamy but could not be passed in both the houses. And then subsequently, though he was not removed through the impeachment process, but through the internal inquiry, then Chief Justice of India passed an order not to allocate any job to or not to allocate any case to V. Ramaswamy. So as per the reports, for 3 years, he was not having any case and he was not allocated any case, although he got the salary and he was not removed. So that's the level of independence that is given to the judges. Justice Soumitra Sen, who was the Calcutta High Court judge, in fact, against him the motion was introduced and then he resigned after it was passed in one of the houses. And the P.D. Dinakaran, Justice P.D. Dinakaran was the Chief Justice of the Sikkim High Court at that point of time. He also resigned from the service after his motion was introduced. And there were talks of introducing motion against Justice J.B. Paridwala, who there was an allegation against him because he used some casteist remark in one of his judgment. But later he removed that particular part. Subsequently, the motion was not introduced. And Justice C.V. Nagarjuna, so there was an allegation that he involved in a harassment of one of the junior staff, and that too on the basis of caste. So later, although the members wanted to introduce a motion against him, but it never materialized because the presiding officer did not allow for it. And then the Rajya Sabha, in the Rajya Sabha, they also wanted to introduce a removal motion against Chief Justice Deepak Mishra few years back on the grounds that he is misusing his authority as a master of roaster when he was Chief Justice of India. But this was also never introduced because then Chairman of Rajya Sabha did not allow for it. So therefore, 6 times it has been triggered, but 3 times it has been introduced. The motion has been introduced, but none of these times the motion has been passed in both the houses of the parliament. Okay, so these are all some facts, because one thing is sometimes a question can come from facts also. That's why I'm trying to cover the relevant facts as well. So what are the areas from where the question can come? So they can ask anything from the removal process. They can ask about the majority, they can ask about the grounds, they can ask whether the grounds is mentioned in the constitution, is it defined in the constitution. They can ask questions from the Judges Enquiry Act. As per the Judges Enquiry Act, the 3-member committee, who shall be part of the 3-member committee, how many members have to support the introduction in Lok Sabha and Rajya Sabha. Any of these things can be asked in the examination. All right. So please come to the next topic. The Supreme Court allows the High Court to appoint ad hoc judges to reduce a massive backlog. So this is again a very important development in addition to what is given in the Constitution. Recently, the Supreme Court has passed a judgment, and in fact, it has relaxed certain norms and rules as to who shall be appointed as, or under what circumstances the ad hoc judges shall be appointed to what is called as the High Courts. And in fact, this judgment was given on the basis that to reduce the pendency of cases. Today, there is a lot of cases that is pending in the High Courts, and to reduce the pendency of the cases in the High Courts, one of the reason it is found that there is a lot of vacancies in the High Courts. And one way of addressing these vacancies in the High Courts is by appointing what is called as the ad hoc judges. Ad hoc judges means temporary judges for a temporary period. And who is usually appointed as an ad hoc judge is a retired judge of a High Court. So any retired judge of High Court can be appointed. Is there a provision in the Constitution for that? Yes, Article 224A of the Constitution provides for it, which was inserted by the 15th Constitutional Amendment Act. So although there is no provision in the original Constitution, the 15th Constitutional Amendment Act, which inserted Article 224A, allowed for this. And this was subject to a lot of judicial scrutiny, and earlier itself the judiciary has given certain conditions under which the ad hoc judges can be appointed to the High Court. what are the conditions on which it can be done. But recently the Supreme Court has amended certain rules under what conditions the ad hoc judges can be appointed to the high courts. First, let us try to understand the provision of Article 224A. So what Article 224A of the Constitution is saying? It is saying that the Chief Justice of the concerned High Court, with the prior consent of the judge and with the prior consent of the President, can allow for the ad hoc judges to perform or to become the judge of a High Court. This is basically how the ad hoc judges can be appointed. So who shall do all those things? The Chief Justice of the concerned High Court, but with the consent of the President of India and with the consent of the concerned judge who is to be appointed. So these things can happen. So it has to be initiated by the Chief Justice of the concerned High Court, but it can be done only with the consent of the President and also the consent of that particular judge. But what is the elaborate process as to how this is happening is not mentioned in the Constitution. But the Constitution says whenever an ad hoc judge is appointed, that is a retired judge who is appointed as an ad hoc judge in the High Court, then he can exercise and enjoy the same privileges. He can exercise the same jurisdiction powers as that of a judge of High Court. He can receive such salaries and allowances as may be determined by the President by an order. But otherwise, he is not deemed to be a judge of High Court. He is not considered to be a judge of High Court, but he can exercise similar privileges. And he may receive salary as determined by the President of India. So this is what the Constitution says. But however, how an ad hoc judge is to be appointed is not mentioned in the Constitution. And that is based on the memorandum of procedure that is issued by the Supreme Court in the second judge's case. The second judge's case is also significant for another reason, which is also called as a Supreme Court Advocate on Records versus Union of India case 1993, which is also called as a second judge's case. In this case, the Supreme Court came out with a memorandum of procedure as to how the judges shall be appointed based on what is called as collegium system. In fact, this is the genesis of collegium system also. It is this case that introduced the collegium system. So in this case, as a part of the memorandum of procedure, the Supreme Court also laid guidelines as to how an ad hoc judge shall be appointed to the High Court. So as per the memorandum of procedure as to how an ad hoc judge is to be appointed to the High Court, the memorandum of procedure MOP says that first the process has to be initiated by the Chief Justice of the concerned High Court. The Chief Justice of the concerned High Court will discuss with the particular judge, and the Chief Justice of the concerned High Court will fix a tenure. And then subsequently he will forward this report to the Chief Minister of the concerned state, and the Chief Minister will further forward it to the Governor, and the Governor will forward it to the Ministry of Law and Justice, Ministry of Law and Justice in the Union Government. The Ministry of Law and Justice in the Union Government will forward this to the Chief Justice of India. The Chief Justice of India with his remarks will forward it to the Ministry of Law and Justice again, and then further it will be forwarded to the Prime Minister, and then the Prime Minister will forward it to the President of India. And once the President of India gives approval, then such a judge can be appointed as an ad hoc judge. So therefore, the only thing that is given in the Constitution is the Chief Justice of India with the prior consent of the particular judge and with the consent of the President can appoint the ad hoc judges. But all these process has to be followed as per the memorandum of procedure. But even if you don't remember the memorandum of procedure, that is not very important. You don't have to remember that. But what is very important for the examination is that the Chief Justice of the concerned High Court has to take the consent of whom? Has to take the consent of the judge and also the President of India. So this thing that you'll have to remember. Now, in a case which is called as the Lokpal case in 2021, the Supreme Court of India has laid down certain guidelines as to under what circumstances an ad hoc judge can be appointed to the High Court. So for which they have laid down certain parameters, certain criteria, although this is not an exhaustive criteria, but some of the criteria is what I am going to present. So some criteria has been laid down by the Supreme Court in 2021, which is also based on what is called as a Lokpal case. Under what circumstances an ad hoc judge can be appointed to the High Court? So one is if the vacancies in that particular High Court exceed more than 20%. Suppose if the authorized strength is 20 and there are more than 4 vacancies, that is more than 20% vacancies, then you can appoint an ad hoc judge. Or if there are more than 10% of the High Court cases are pending over 5 years. Suppose if there are 50,000 cases, 5,000 cases are pending over more than 5 years. this is true in most of the high courts. So therefore, there's a possibility they can appoint. If a case dispersal rate is lower than which the case is filed, that is, the admissions or the number of cases that is admitted is much more higher than the number of cases that has been disposed, then also you can, the Chief Justice of the concerned High Court can appoint what is called as an ad hoc judge. Or if the cases of a specific category of case, civil cases, criminal cases, they are all specific category of cases. If a specific category of cases is pending for a long period of time, that is, if it is pending for more than 5 years, these are all the grounds on which the High Court or the Chief Justice of the concerned High Court may be convinced in appointing an ad hoc judge. So this is what the conditions laid down by the court says. Now coming to the current part, so some of these rules has been relaxed by a 3-judge bench of the Supreme Court recently in order to enable the High Courts and the Chief Justice of the respective High Courts to appoint more ad hoc judges. So what are the conditions that has been relaxed? In fact, the important condition that has been relaxed is earlier if the vacancy exceed 20%. So this is not necessary. Even if the vacancy does not exceed 20%, still they can go for appointing what is called as the ad hoc judges. But however, an additional rule has been brought in. So whenever an ad hoc judge is appointed to a particular High Court, those judges should be part of a bench where a regular judge sits. So they cannot separately decide the case. That is very important. So whenever an ad hoc judge is appointed, a retired judge for a specific number of years, as decided by the Chief Justice with the consent of that particular judge, retired judge, and the consent of the President. So that judge cannot decide any case separately. He has to sit along with a regular judge as a part of that particular bench. And he can sit only in the criminal cases, not in any of the other cases. Okay. So they can hear only in criminal cases. So this condition has been brought in, but this condition has been relaxed. And additionally, the number of ad hoc judge cannot be exceeding 10% of the court's sanctioned strength. So this condition has also been brought in. Suppose if the court sanctioned strength is 50, the number of additional judges that can be appointed cannot be more than 10%. That means maximum how many ad hoc judges can be appointed? Maximum 5 judges. So therefore, depending upon the strength of various high courts, they can range from 2 to 5 judges maximum. So, okay. So this is what it says. This is not a general rule. This is the probability that is put. But you can remember the rule is the number of ad hoc judges should not be more than 10%. All right. So these are all the things that you'll have to understand. But to what extent do you think this provision has been used in our country? The number of times this provision has been used is very, very less. So in the entire judicial history of India, it has been invoked only 3 times. One in 1972, other in 1982, and other in what is called as the year 2007. But in fact, it was never used after 2021. Although a judgment was given in 2021, now again the judgment has been given. But we'll have to wait and see whether this happens or not. But however, Article 224A becomes very, very important to appoint the ad hoc judges. Who are appointed as ad hoc judges? A retired judge of High Court. Who shall appoint an ad hoc judge to the High Court? The Chief Justice of the concerned High Court with the consent of the President and the concerned judge. So the elaborate process is not given. And the salary allowances of the ad hoc judge to be determined by the President. He will exercise all the powers, jurisdiction as that of a other judge of High Court, but otherwise he is not deemed to be High Court judge. And certain restrictions has been passed by the certain relaxation, certain restrictions has been passed. So this also you may remember. So these are all the areas very important for your examination. All right. So one last topic which I found also may be important, although it is not directly related to the judiciary, but it is related to one of the doctrines that is innovated by the judiciary, that is the rarest of rare doctrine. So you should know as to what is this doctrine and in which context this news becomes very important, because if you look into one of the unfortunate event that has happened in the country in the last year is the rape and subsequent death of one of the post-graduation doctor in West Bengal, I think in Kolkata, in a hospital which is called as RG Kar Medical Hospital. And that news was very sensational throughout the country, and unfortunately this incident has happened. And then subsequently the trial was conducted by the CBI, and then subsequently on prosecution, now the judgment has been given to the accused, and the judgment that was given to the accused is only life imprisonment and not death punishment. And then subsequently there was a lot of protest also. So a number of articles came in the newspaper as to why the death punishment has not been given, because the judge who was conducting the trial in the RG Kar case was convinced that it does not fall under the rarest of rare doctrine, and therefore he is not in a position to award what is called as death punishment. So a lot of articles were comparing. On the one hand, there was a case which is called as the Sharon murder case, Sharon Raj murder case, where in this case Sharon Raj was murdered by her partner because a partner has given him a poison, and consuming the poison, after a few days he died. On the other hand, the R.G. Kar Medical College, there was a brutal rape, and then subsequent to that there was a murder. So while the judges were of the opinion this falls under the rarest of rare doctrine, and they have given what is called as the death punishment, whereas here in this case the district judge was given only what is called as the life imprisonment. So therefore a question was raised in number of news articles as to what is this rarest of rare doctrine and what are the issues it is surrounding. So rarest of rare doctrine states that the judiciary has upheld this particular principle of death punishment or capital punishment provided in certain exceptional cases or in rarest of rare cases after looking into the aggravating as well as the mitigating factors. And then the judges can give even the capital punishment, and giving death punishment or the capital punishment does not breach the fundamental rights because the fundamental rights are not absolute. So in rarest of rare cases, capital punishment can be given. And in fact, this rarest of rare doctrine was put forward by the Supreme Court in a case which is called as the Bachchan Singh case in 1980. Very famous case. And what is this rarest of rare doctrine as per the Supreme Court in the Bachchan Singh case? The rarest of rare case or the rarest of rare doctrine means that before giving the judgment, the courts or the judges have to look into both the aggravating as well as the mitigating factors. And after looking into this, they can be given death punishment if the aggravating factors are far more than that of the mitigating factors. Now, what is an aggravating factor? Aggravating factors are those factors which make the offense more grave. Say for example, how the offense has been committed, under what situation it has been committed, what are the kind of torture that the victim has suffered before the death. So these are all aggravating factors. What are mitigating factors? Mitigating factors is what is the mental state of the individual who has committed the crime. Is it for his own private defense, or is it for any of the other reasons? Is his mental state is not proper, or for, that whether that has happened only in a immediate instinct and without any motive probably, or that individual though has done that particular offense has a very good track record of being a good human being in the society. So these are all mitigating factors. So after considering all those things, probably the punishment can be given. So yes, in rarest of rare cases, the death punishment can be given. But this is not the first case where the capital punishment was recognized. The capital punishment or the death punishment was recognized way back in 1972 in case what is called as the Jagmohan Singh versus state of Uttar Pradesh, and then subsequently the rarest of rare doctrine was brought in Bachchan Singh case. But even after the rarest of rare doctrine was brought in the Bachchan Singh case, there are no clear guidelines and they continue to exist lot of discretion in the hands of a judge. So the Supreme Court thought of giving certain guidelines as to how this rarest of rare doctrine has to be used in a case which is called as the Machi Singh versus the state of Punjab case in 1983. But however, even today the problem is that still there are I would say criticism that a lot of discretion is there in the judges as to what amount to rarest of rare doctrine, what amounts to mitigating and aggravating factors, and that's the reason these differences exist. So in this context, a lot of news has been published. That's why I wanted to bring it to this. So while the current facts may not be relevant, but what may be relevant is you should have an idea this rarest of rare doctrine is related to what, in which case this was brought in. So such factual things may be asked in the examination. All right. So with that, we'll wind up the discussion with regard to the judiciary, because our idea is to look only into the important topics, not each and every topic, because they may not be of much use. So today the ad hoc judgment, I would say, sorry, the ad hoc judges appointment is very, very important. Removal of the judges, very, very important. The conventional practice related to what is called as the appointment of Chief Justice, very, very important. Whether the judges of the High Court and the Supreme Court, or they consider to be what is called as a public servant, that can also be a potential question. And then the last thing is, yes, of course, we have seen the rarest of rare doctrine. So these are all very important for your prelims 2025. If you have any questions related to any of the topics, you can reach out to me. You can reach out to me either through my Telegram channel or through my Instagram account. I'm sure that the students who watch all these lectures, there are 7 to 8 lectures, probably I'll cover around 50 topics from the major subtopics in the subject Indian polity. A lot of conventional areas may also be covered, but more emphasis will on be at the current affairs. This is not only relevant for the students appearing for Prelims 2025, but also students who wanted to prepare for Prelims 2026, because you get to understand what type of topics are relevant and in every topic how you have to read. So that is how I am trying to do this particular series. So if you have any queries, you can reach out to me. You can think me as your friend, guide or a mentor who can help you in clearing this examination. Thank you very much. All the very best. In the next episode, we'll deal with the fundamental rights, which is even going to be more interesting. Thank you very much. Once again, all the very best.